Yes, yes, Mr. H. The issue has been decided.
Yes. Not,
We will just look at that and then we'll give you.
yes. In fact, the judgment that he will cite is 2023 Volume 6 BLJ 182.
Is it Abhay Kumar Patel?
J.
I have a copy.
And in that judgment, particularly, kindly see what was
उसके
this.
बाद आपका भी जजमेंट है
What was this stress? The stress was with regard to retrospective operation of the rules.
नो एंटायर जजमेंट वाज चैलेंज एंटायर रूल्स वर चैलेंज
Right?
नॉट ओनली रिट्रोस्पेक्टिव
But kindly see the
एक कोर्ट मास्टर साहब ये भी देखो Rule 8 itself was challenged on several grounds, including retrospective.
but the main stress in the submissions as evident from paragraphs 3 onwards.
Just a minute. Give us 1 minute. Yes, tell us.
Insofar as Patel's judgment is concerned, right from paragraph 3 onwards, my lord finds that the rules notification was made.
What are you contesting?
Lord, I am contesting the quantum of marks and the manner in which it is being reduced. So far as the raw marks obtained in the written examination are being reduced by multiplying it by 0.75, and then raw experience marks are being added to it. I will show the inequality straight away. Kindly come to page 63. Instead of not giving, kindly see what is happening. Page 63. Serial number 21 is Abhishek Kumar. He has obtained 278 marks in the written examination. And by multiplying it by 0.75, his total marks have been shown to be 55.159. And a person who has secured 152 marks, he gets percentage 30.159. 25 marks are added and they become equal. And even more, Lord, page 94.
No, but the experience is said to be counted. This is without experience. This is experience.
Lord, that is what I am showing. Now kindly see, if 25 marks per 100 as per the division bench cited was to be added, then kindly turn to page 89. Page 89. Total written marks is 194. Experience written percentage is 37.5. Experience marks 25. That he gets 62.5. And a person who has secured 306 out of, for the next page, page 90, written percentage is 59.15.
Are you questioning the adding of? Are you questioning the adding of the handicap, or you're questioning the manner in which it is being done?
Manner in which it is being added and the quantum.
So manner, it is quantum, that 5 that has been approved.
Lord, in fact, there, so far as there's not of Patna, but there's a division bench of Rajasthan which has taken into account all these factors, that what could be the maximum.
What could be done? It's a judgment by division bench. The matter is pending consideration.
Now kindly
At best, you can go and be an intervener there.
Now kindly see, if total written marks obtained by this candidate with
Quantum is out
experience.
of question for us to consider now. Now you talk about the manner, that perhaps.
Yes, my lord. I will talk.
So
just,
therefore, that does not
just to
mean-
show,
that does not make it a validity issue.
just to show that 0.75 it is not added, not multiplied by this, page 89.
Nothing.
Then 194 plus 25 would be
The process is afoot, no?
the process. In fact, my lord, kindly see the notification on the basis of which this amendment has been made. The General Administration Department, page 80, the resolution dated.
And what did you say? Abhay Kumar is pending before Supreme Court. And what is the challenge?
No,
The judgment itself is there.
By whom? By state?
No, no. Why should the state take?
Well, that, what is it?
By the applicant.
वहीं कही है. We will keep it pending till the disposal. You have the number.
Yes, I have given the number.
एक चीज खाली देख लिया था.
अभी नहीं कर सकते, Mr. Pushkar. You understand this? We can't. Wherever it is possible for us to interfere, we shall.
General Administration
Paragraph
Department.
7, I have given the number.
If my lords will kindly see the resolution at page 85, relevant portion, just 2 lines. Just satisfied.
Just
What the
give me
resolution
one
says. What the resolution says. Lord,
Can you give us 1 minute? Just 1 minute. Yes, you're talking about resolution.
yes, the resolution of the General Administration Department dated 22nd January 21 starts from page 80. The relevant portion is at 85, clause 4. This is with regard to all services. Now, नियमित नियुक्ति में अधिमानता. नियमित नियुक्ति किए जाने के क्रम में संविदा नियोजित कर्मियों को नियुक्ति की प्रक्रिया में निम्नांकित अधिमानता वेटेज दी जाएगी. 1. संविदा के आधार पर पूर्व में अभ्यर्थी द्वारा प्रतिवर्ष की गई संतोषजनक सेवा के लिए अधिकतम 5 अंक प्रतिवर्ष की दर से अधिकतम 25 अंकों की मार्क्स की अधिमानता किसी वर्ष के अंश के लिए कार्य दिवसों को संख्या में 5 से गुना करके पश्चात 365 से भाग देकर प्राप्त अनुपातिक अंक जोड़ा जाएगा, दी जाएगी. और they're talking about addition of 25 marks of a maximum. Now, so far as the resolution, the notification of Road Construction Department annexure E/2 at page 77 is concerned, kindly see that, what they have done. Page 77. Now, Lord, the merit list of the candidates shall be prepared on the following basis. Weightage of marks obtained in the written examination conducted by Commission 75 marks. B. Maximum weightage for the working experience on contract basis. The weightage of per working year shall be 5 marks subject to maximum
They
limit of...
repeat what the resolution says.
Now, now the note, my lord, to calculate the weightage of marks in the examination, the percentage of marks obtained in the examination shall be multiplied by 0.75. Now kindly turn to page 89 once again, and I will show that if it had it not been reduced by way of multiplying it by 0.75, the candidate at page 89 would have had 194 plus 25 at maximum. He would have been less than a person who has secured 306 marks total. So instead, what they are adding raw experience marks to percentile marks, which is nowhere provided in the resolution. And the inequality is apparent from page 89, that if written marks 194 is added with experience marks 25, the result would be 200 and not 9 or 19, 219. And so far as the candidate who was without any experience at page
Just a minute,
90.
just for our understanding, so the main
My
issue
lordship.
if the main issue falls, the rest of the things fall. But why?
My lordship will yes. 25 is on the scale of
25 is on the scale of 100.
100. If it is 400, then naturally my lordship will have to work out on the scale of 100.
25, yeah, this is the weightage.
Suppose
Out of 100,
suppose the
25.
selection test is 100, only 100. Then 25 marks if 5 years experience. 25 marks will be allowed. However, if the selection test comprises of test of say 400 or 500 marks, then my lordship will not remain 25. 500 will be reduced, my lordships, by this formula, that is 0.75.
So next page 78, that is the weightage marks would be the marks obtained in the maximum or full marks of
Marks
the
obtained in the examination. Full marks of examination.
Our ek hi hai, full marks of
And 75.
into 75.
That's right, because 75 is, my lord, the marks on the scale of 100.
So I say that if raw marks are added to raw marks, then result is different. 194 plus 25 experience, result is 219. And now here, and by reducing it, you get 62.5%. And in next page 90, a candidate who has secured 306 out of 400, he gets 59.15. It is wholly iniquitous. And in my respectful submission, so far as
No, the examination was for how many marks? Papers?
400.
400. So it had to be reduced to the scale of 100, then
Yes.
only 75.
Yes.
Lord, this is what, but the resolution of the
Otherwise, how would this weightage formula would be
so
divided?
therefore, so that is one aspect
If
of the
the
matter.
argument is accepted, then for 100 also to 125,
No, no.
not 425.
Now
That will be inequitable.
they are saying that 25 marks. Therefore,
No. What is your challenge? That this formula
the formula is wrong.
incorrect.
And number
Why?
two,
How do you say that formula is wrong?
my lord, by I'm showing it by
No,
annexure.
don't show that, because there would be many other variables which would have added to the final number.
My lord,
Now tell me.
we have attempted
Just
to,
a minute, Mr. Shai. You may have pursued science in your graduation or maybe in your intermediate. I was an out and art student with poor ability in mathematics. Now you are saying this percentage I can only understand that to bring it to the scale of 100, some formula has to be devised. Now this formula has been devised by the government, by the road construction department, which is undertaking the exercise of a formula. And this is by virtue of resolution which has been found to be correct. Now that it would create anomalous results is for you to prove. Now we don't understand this, that by multiplying the marks into 0.75 we understand this, because the marks out of 100, see, the calculation was that written marks would be calculated on the scale of 75%, if it is 100 is the marks, and 25 maximum of the experience, right? So this 25 remains intact. It
Yes.
cannot be more than 25, this 25 remains intact. But suppose the paper is not of 100 marks, no, the maximum marks is, I don't know how many, 400, 500. So how will that be calculated? Therefore they have done it by 0.75.
Lord, that is what we have attempted to, Lord, address in paragraph
That means,
10. Paragraph 10.
percentage is multiplied by 0.5, 0.75. तो 75% हो गया.
और ये on
Percentage कर दिया ना. To calculate the weighted marks in examination, the percentage of marks obtained in the examination. Written.
and my lordship will kindly see.
Multiplied by 0.5.
That is one. The
My
other
lordship
is
will kindly see
the
the division
other-
and judgment.
Huh?
in division bench judgment, this formula has been discussed in para 31.
Then what is there? Then what is there, Mr. Shahi?
Yes.
Lord,
Kindly come to para 31.
this is what I'm, and then the quantum, my lord, entire judgment in Patel's case, my lord, deals with retrospective operation of the notification and rules.
Kindly see, my lord, para
One
31.
by way of, so therefore, whether in that judgment, the quantum of marks, the judicial precedents in respect thereof have not been taken into
My
consideration.
colleagues' clients are confused. Confused to the extent that they do not appear, my lordship, sound.
They are more meritorious, that is why they are before this court.
Provide for appointment process based on
And even otherwise, this judgment also you have appealed against. Are you the appellants before the
No,
Supreme Court?
I'm not, but
The
yeah,
affidavit says so.
then, my lord, the quantum,
they are,
so far as Rajasthan
These
High Court is
petitioners,
concerned,
They are the
directly,
appellant. They are
and
filed.
now the next date of hearing is 18 to 25.
Sorry, sir. If you have preferred the SLP, why are you bothering
no,
us?
we have not.
This is the statement.
No, these petitioners,
These petitions, not here.
not here. The petitioners, my
We have
lord.
not. So,
Same issue, my lord.
just one paragraph of Rajasthan High Court.
Wahan
Why
kya
do
hai?
we see Rajasthan High Court?
Lord, they
We have a
considered,
judgment of Patna High Court.
they considered, my lord,
Just a
that
minute.
there is no binding
You
precedent.
could have argued that the division bench judgment is per incurium or bad. It needs to be decided by a higher bench.
Lord, that is also one of.
We can't because the matter is under challenge before the Supreme Court. So you have to await the verdict of the Supreme Court. Otherwise, a superior forum has been used.
No.
Otherwise, this argument at best could have been your understanding your position and the difficulty in which we would accept your arguments, even if it were true, even if it were correct.
Lord, just for my satisfaction, could you kindly just see paragraph 56?
To what avail, Mr. Shahi? To what
That-
avail?
They say that
We
no
will see
other-
everything. If you ask us to devote our time to this, we will devote till 4:30. But tell me, to what avail? When the
After
issue
SLP?
itself, including the computation formulae, if this is under challenge, can we say that the division bench decided wrongly? Can we?
Lord, if my lords will peruse the entire judgment, all
That's under challenge.
and so one thing is there that it may come up after SLP. The other thing is that otherwise the division bench,
That is also not going to help you.
otherwise the division bench, in my respectful submission, decided only the issue of
You will be happy
retrospectivity.
if you will not require any argument if the SLP turns it down. In the SLP, the Supreme Court turns it down, says that this is bad. That will apply to you also.
We have tried
Next
to-
date is 18th as I have.
That
Yeah.
is applied to everybody.
we have, my lord, in paragraph 10 onwards, attempted to show the mathematical flaw in the calculation methodology. If my lords will see.
All right. Heard Mr. Pushkaman Chai, learned senior advocate for the petitioners and the learned advocate general of the state. The petitioners have called in question the amended rule 8(5) of the Bihar Engineering Service Class 2 recruitment amended rules 2022 and have prayed that the rules be not given effect to in the selection process under advertisement number 32 of 2024 and 33 of 2024 for the posts of assistant engineers (civil/mechanical), as also for stopping the incorrect formulae arrived at so as to ensure that as also for being used in any future recruitment process. It appears from the records that pursuant to resolution number 1003 dated 22/1/2021 of the GAD Government of Bihar, the amendment was made in clause 8(5) of the rules of 2022 referred to above, giving weightage to contractual employees in appointment for regular service. The issue was debated before this court in CWJC number 18302 of 2022, wherein a division bench of this court, by judgment dated so and so, judgment dated 5/7/2023 upheld the validity of the amendment, as also the formulae evolved for bringing and collating the marks to the scale of 100. The formulation, the formulae was necessarily to be fixed for the reason that 25 marks in maximum was to be given weightage to be calculated on the basis of 5 marks for one particular year of having served on temporary basis. The aforementioned judgment is under challenge before the Supreme Court by SLP number 22323 of 2023. The contention of the petitioners here is that not only the introduction of the principle of weightage is incorrect and is against the overwhelming number of decisions by different courts, but even the formulae for calculating the marks on the scale of 100 is rendering anomalous results. We are afraid such objections cannot be raised at this stage when a judgment of the division, a judgment by the division bench of this court has upheld not only the modification in the rule, the amendment in the rule of 2022, rule of 22, amendment in the rule of 2022, and even the formulae developed for calculating the marks on the scale of 100. Since the matter is pending consideration before the Supreme Court, and the matter is pending before Supreme Court, there will be no good use entertaining this petition any further. The petition is dismissed. Amendment in the rule of 2019 by way of amendment of 2020. You could have asked for. You could have asked. I think it is there. This will await. No order will be after the SLP. उसको लास्ट में काट दो. I will put it after the decision on this. So the issue cannot be decided here presently, as the matter is pending consideration before the Supreme. Let this case be listed after the disposal of the aforementioned asset. Yes.
Lord, may I see paragraph of the judgment of the Supreme Court?